SJC-11550, Commonwealth versus Amos Don.
Thank you.
Mr. Wood, good morning.
May it please the court. Chauncey Wood for the appellant Amos Don. The Commonwealth's murder case against Amos Don depended entirely on two things. First, the testimony of Shamik Garcia that the last thing he recalled before being shot was, one, sitting in the driver's seat of his car, two, seeing Amos Don get in the back seat, and three, turning to his right to look at Don. Second, the testimony of Sergeant Doherty that when he arrived on the scene, he asked Garcia, as Garcia was lying on the ground, mumbling incoherently, "Who shot you?" And Sergeant Doherty concluded that Garcia's repeating the statement, "Ace, ace, ace," was an answer to his question, "Who shot you?"
Okay.
The defendant was Ace.
Now you're arguing that defense counsel should have brought in an expert about the defendant's mental ability to repeat that information?
Yes, that's my
All
second,
right.
my second
That's your
argument.
second argument. So
Yes.
with regard to that, on that point, what does your expert say now on a motion for new trial in this regard?
So my expert is Dr. Ryan Darby, board-certified neurologist. His affidavit is in the record appendix, and it was submitted to the trial court, so it's part of the record. So he specifically says there's really no dispute in his mind, first of all, that there's powerful reason to doubt whether Garcia was actually answering the question. There are a number of reasons that make it clear that that's subject to serious doubt. You can begin most obviously with the fact that the next question Doherty asks is, what's his real name? Ace. Where does he live? Ace. Doherty himself recognizes he's not answering my questions. That's his testimony. So Dr. Darby, looking at all of this stuff, is really not really even pausing much about the question whether there's reason to doubt that this was an answer. He's really addressing what's the neurological explanation for this, that he lacks the capacity. And this is the crucial point and distinction. This is not about memory. This is about capacity to answer a question, a neurologically distinct issue. And Dr. Darby is addressing that point, which was never addressed. So that's what he's addressing.
Okay, if I could stick with this, I know you want to go back to the first, and we will. He wouldn't be, if he were to have testified, you agree that he would not have been allowed to say, in my opinion, this particular Mr. Garcia, because of the injury to his brain, was not in a position to answer questions? Or are you saying that that would have been permissible?
So the case law, I think, is quite clear that you cannot address the credibility. You cannot say whether someone is telling the truth or lying. I think that you absolutely could testify that someone lacks the neurological capacity to make decisions. And Dr. Darby, another point that he makes in explaining the basis for his neurological opinion is that the frontal lobe, where Mr. Garcia was shot, which was damaged, controls decision-making ability. Answering questions, although perhaps we don't commonly think of it this way, is a decision-making exercise. The frontal lobe does not control language, he would point out, he would explain, but it does control decision-making ability. And so with a damage, I'm saying he would be allowed to testify to all of this.
Okay, so I'm trying to get your best case in terms of what would have, what arguably could have happened. So it seems to me that what you're saying is that the best case would have been to say that, without speaking about this Mr. Garcia specifically, a person with the neurological damage suffered by a person would not be in a position to make any decision, including to be responsive to questions. Is that the best case, or you think?
No, I respectfully, I think that the best case in this, I think in this case, if it were me, I would call Dr. Darby to testify that I examined Mr. Garcia's records and the forensic evidence, the police officer's testimony, everything that is available to me. It is my professional opinion to a reasonable degree of medical certainty that Mr. Garcia himself, specifically as a result of his damage and as a result of the forensic information I have in front of me, lacked the capacity, or there's a reasonable doubt, or there's a significant doubt, that he lacked the capacity to make decisions, including to answer the question, who shot you? That, in my opinion, he did not have the ability. And that is not a question of credibility, and therefore there is, as far as I'm concerned, that's entirely permissible, that he would have been able to testify. In this case, Mr. Garcia was not, in my opinion, able to answer a question, any question, at the time Sergeant Doherty asked him a question. It's not about whether that was an answer. That's the best case. Now, on the first question, I think that it is crucial to understand exactly what the new medical records demonstrate. Shamik Garcia's complete medical records demonstrate that he was shot in the mouth, and this is very anatomical and I have to be very specific, shot in the mouth, and that the trajectory of the bullet in the interior of the mouth, not through the exterior, through the cheek, but in the interior of the mouth, and the bullet traveled in a left to right trajectory, shattering inside his right temporal lobe, right here. So that is crucially exculpatory evidence because it undermines the central point in the Commonwealth's theory that he turned to his right back to see Mr. Don. It's our position that at the very least, this would have been a real factor in the jury's determination. But indeed, I think this is clearly evidence that he could not possibly have been shot by someone sitting in the back seat of the car.
And you only learned this from the new medical records that you received?
Yes, so
That's not the Commonwealth's position, is it?
No, let me be clear. I think I know what your Honor's getting at, and let me be candid and clear. In the first batch of medical records, the Commonwealth, first of all, to set the stage very briefly, the Commonwealth requested from BMC all medical records. The BMC released what they purported to be all medical records. Defense counsel requested in mandatory discovery all medical records. So defense is reasonably thinking I've received all medical records. In 563 pages of BMC records, there was one document which included one page, RA-198, if you're trying to, RA-1A-98, if you're trying to find it in the record, that arguably provides most of this information. So you could make the argument that this is not newly discovered. The Commonwealth does. I submit that that's a needle in a haystack, that's missing the forest for the trees. I submit that it's still newly discovered because that was a pre-surgery report.
Where did you get that was more? Where did you get that was different?
We got the entire, we got the radiologist's report. That one document is a pre or post-surgery from the surgeons. This, what we didn't get, and what we now have, which is RA-1B 2367 and other documents, is the complete radiology report of the radiologist. As soon as he's brought in, within an hour of being brought in, he's sent to a CAT scan. He gets a CAT scan, the radiologists look at the films, and they conclude several things. But they, most importantly, very specifically go through the anatomical trajectory of the bullets. So the defense counsel did not have the radiologist's reports of the CAT scan taken within an hour of him being brought in. That's what they didn't have, and what I submit is the material crucial evidence here. But if the court wants to take it, sorry,
backwards for a second, because I'm still trying to understand. So we've got two people in the front seat of the car who are shot.
Yes.
Do we know? And I couldn't tell from reading the briefs that the same gun killed both people.
There's no opinion. Actually, I don't want to misstate the record. I cannot remember. There was a testimony from one police officer about the bullets. There was no gun recovered. I cannot remember, actually, if there was an attempt. Well, the only bullet, I just can't remember. I can't remember.
I'm just, again, I'm trying to, and I'm way behind you for a second.
Sure.
So I've got two people shot in the head.
Yes.
The trajectory of the person, of the girlfriend was what? Sorry.
So the girlfriend, Erica Field, and I just need to preface this very briefly. When we say we have two people in the car, all of that is
two people shot in the car, right?
Right, two people shot in the car. I just want to preface all of what I'm about to say with, what we have is the testimony of Shamik Garcia.
Right.
And a big part of my argument is we can't rely on anything Shamik Garcia says. But assuming we accept Shamik Garcia's statement that he's in the driver's seat and Erica Field is in the passenger seat. To answer your question, Erica Field, passenger seat. She, as far as we can tell, roughly, holds up her left hand to her nose and eye area, and a bullet goes through her hand, through her nose, and into her brain. A second bullet.
Meaning that she's also shot from the side, back, or, I'm just trying.
She's shot from the left side. Both bullets, it seems, enter the left side of her head. The second bullet, there's two bullets. The second bullet is behind her left ear. Now, I think what the Commonwealth will argue, certainly, on this point that you're raising,
Right.
Can't we infer from Eric, forget about Shamik Garcia, forget about his reliability, forget about medical records on him. What about Erica Field? Doesn't the trajectory tell us that she was shot from the back? No, it does not. Because all we really know is that she's turning, first of all, she's moving, and we don't know what her position was at the time she was shot. If, for example, and the defense counsel could have reasonably argued this, the shooter was outside the driver's side window. There's nothing inconsistent with the theory of the driver being outside the driver's side window, reaching into the car, shooting Erica Field as she turns, first of all hitting her in the hand and nose, and then as she turns away, naturally, from a bullet, a gun, getting hit behind the nose. The Commonwealth might point to the trajectory rod of Mr. Kosiorek. In fact, that trajectory rod helps us more than hurts us because it suggests that the bullet came through the passenger seat, but there was no damage to the passenger seat. And furthermore, you would have been struck in the body, not in the head as she was, indicating, we submit, our expert submits, that it must have been a ricochet. That bullet must have hit her bones and anatomy and ended up in the door. And then finally, there's stippling on her injuries. I'm sure the Commonwealth will bring that out and say, that demonstrates that she was shot at very close range. The Commonwealth's own medical examiner testifies that, in fact, that is no indication of anything more than a gun being 3 feet away. She has seen stippling. In her opinion, there's stippling up to 3 feet away. This is a very small car. The photographs are in the record. It's a compact. I submit that that is also consistent with a shooter being outside the window or standing outside the window, reaching into the car and shooting Miss Field in the head. So that's a long answer to your question, which I think is a fair question.
So you're to oversimplify, the possibility that the person is outside the car is consistent with the trajectory evidence as well as the person being seated behind the driver and firing.
I'm saying more than that. I'm saying that the first part I absolutely agree with. It is consistent with a person being outside the driver's door. I am saying emphatically, at least with regard to Shamik Garcia, it is flatly inconsistent with a person sitting behind him.
Why not? Well,
Because-
that part I don't understand. If
Right.
he's turned around, there's more than one bullet fired, right?
At Mr. Garcia, no, only one.
No, but there's more than
yes.
one bullet fired in the car.
As far as we know, there are 3 bullets fired. 2 at Miss Field, 1 in Mr. Garcia's
Why
head.
can't the person, why do we rule out the possibility that Mr. Garcia is turning around and shot in the face while the other person is shot from the side? I'm trying to figure out why you rule that out, or from this new evidence, or why it's equally plausible.
Yes, it's very important to be very specific about this issue. And I was trying that, and I'll make another pass. Mr. Garcia testifies that he's sitting in the driver's seat, and he turns back towards his right to Mr. Don.
Mm-hmm.
If you're turning to your right, and first of all, it's virtually impossible for someone behind you in a compact car to shoot you into interior of the mouth. We're not talking about the exterior. It would have been plausible to shoot somebody if their face is turning to the right in the exterior of the right side of the face, through the cheek, for example. And that's what the testimonies of Dr. Hull allowed for. She was not clear. But it would be virtually impossible to shoot them in the interior of the mouth, or the bullet entering the interior of the mouth, not the cheek, but interior.
She's gonna stand up in a second saying, if he turns around, you can fire it. And you tell us we can't rely on his memory for this, so we're gonna have to rely on the scientific evidence here. I assume she's gonna stand up and say, if he turned around to his left, you could fire into his mouth. Right? Or
Well,
no?
if he turned around, he testified, I turned around to my right. So there's
He was in the passenger seat, right?
No, he was in the driver's seat.
Aha.
Driver's seat.
So,
But the
so
second-
he's basically saying that he basically turned around like this.
Yes.
And do we know whether whether the defendant is right-handed or left-handed?
We don't know whether he's right. I don't remember any record on that, but we do know that Garcia testified that he got in behind the driver's seat. He's in the driver's side.
So the driver is turning around this way.
He was right, yes.
And you're saying that the angle is coming this way.
From left to right, right temporal lobe. And that's the second part of my answer to Justice Kafker. And I don't want to cut you off, but the crucial point is not only is it almost impossible to put it through the mouth, this is more important. If you hit somebody in the right side of the face as they're turning to the right, as Mr. Garcia said, the bullet will necessarily travel from the right to the left. I know it's hard, and you need to think in 3 dimensions, but it's crucial, and I'm 100% right.
I flunked the kindergarten spatial test, so this is hard for me.
For a lot of people, believe me, the mooting of this, we spent a lot of time trying to figure out the best way to explain it, and this is the best way I can come up with, and there's probably a better way. But you're going right to left. So my point, and here we have...
So it's going towards the left
But
ear.
here's the best thing. Touch your right temple. Right temple.
Which
That's
hand?
where it landed.
Of the right eye?
That's where it landed. Now, if you're turning to your right, as Mr. Garcia said, it's impossible for a bullet to enter your mouth and land here. It's impossible.
You're saying it's above the right eye.
Well, it's the temporal lobe is right here. We actually gave you a handy diagram. I credit my associate.
Wasn't that handy, actually, but
It's in the reply brief, but yes.
see, it's above the right eye.
Yeah, the temporal lobe. The temporal lobe.
Bullet lodged
Yes.
around
Yes.
here, above
And it
the
did
right
not
eye.
come out, but yes, it lodged.
Came from at this angle.
Yes, that's right. Interior of the mouth. That's exactly right. And so the point is, and the last piece of this is,
Can I ask one
Sure.
silly question?
sure,
If you're, again, we can't rely on your client's memory for just the reasons you're arguing.
the,
The first
the victim's memory.
victim's memory,
Yes.
just the reasons you've been telling us earlier. So what if he's turned to the left, not to the right? Does
Right.
this all make sense?
So this is also crucial. The Commonwealth's case depends entirely on Shamik Garcia's recollection of events. We submit.
No,
there's-
it
it's-
doesn't, because it also, it depends on the ballistic evidence as well.
Well, no, the ballistic evidence is meaningless for blaming Mr. Don unless you have some reason for Mr. Don to be in a place consistent with the ballistics evidence. The only evidence that Mr. Don is present is Mr. Garcia. We say,
No, there's a lot of other evidence that he's present, right? We have CSLI evidence, we have all kinds of stuff that puts him in the car.
sorry, I want to be clear. There's lots of evidence that he was in the car and they came towards the area. Mr. Garcia's testimony is, and this is the only evidence about Mr. Don's location once they come to this area, is that he gets out of the car and goes to some silver car. And then he claims a series of things that could not possibly have happened. And it's crucial that we get to this point as well. His memory of events between the moment that they arrive in this area and the moment he blacks out is repeatedly, objectively, conclusively wrong. He says that he parks outside this parking lot. He does not. His car is found well inside the parking lot. He claims that that the silver car is in front of them. It is clear from the photographs that demonstrate where his car is parked. He's parked head into a parking lot. No car could have been parked in front of him, much less the silver car. And finally, he claims that Mr. Don gets out of the back seat and walks forward in his field of vision to the silver car. Again, that's impossible. He could not have possibly walked in front of him to the silver car. So repeatedly, in fact, he must have, if anything, walked backwards out of his field of vision. And you know this conclusively from the crime scene photographs, which show us where Garcia's car was parked. So the point is, Garcia is the only person who places Don inside the car, where ballistics evidence would have been at all relevant. And his recollection is repeatedly, objectively wrong. So, in fact, there is no basis to credit Garcia about his recollection. And therefore, if you were to, you're hypothetical, well, maybe Garcia really meant he turned to his left and now it's all consistent, then that's a hypothetical. First of all, the Commonwealth didn't argue that. The Commonwealth argued very emphatically about this theory that I've articulated here. So they can't just, it's rank speculation and a completely different theory, which was never presented to the jury. In addition to all this medical evidence, which was never presented to the jury, in addition to all of this evidence conclusively establishing that Garcia was objectively wrong. None of that was presented to the jury.
Yeah, but you're not asking that much. You're just saying that this expert was helpful enough that you should have a new trial.
And I'm not even saying that. I'm saying, could we please have an evidentiary hearing? We were denied an evidentiary hearing. But yes, that's right. A reason, could all of this together, under 33E, have been a real factor for the jury?
So what do the medical records say with regard to Mr. Garcia's teeth?
With regard to his teeth, I apologize. I looked at 2,400 pages of medical records. It took me a really long time. I am not a doctor. I don't remember anything about his teeth. I don't think that. I don't think I saw any.
So you're suggesting, I mean, if the shot came through his mouth, unless his mouth was wide open, you would think it would damage the teeth.
You would, my best guess. Okay, I'm speculating, but because I did not see.
Don't speculate.
Right,
But
but I think the point was that it hit the palate of the mouth. I'm not a medical doctor.
Okay.
I think that the palate is separate. My vision is, well, let me say this. The radiology report that I've referenced so much, RA 1B2367, the radiologist concludes this was likely a self-inflicted gunshot wound. My image, when he says that, is he thought Garcia stuck the gun in his own mouth, up against the roof of his mouth, the palate, I think, and shot up. I think that would miss the teeth. That's my best guess.
right, well, I mean, yeah, okay. So now the theory which you say is that whatever happened, the shooter basically forced the gun into the mouth.
I'm not going that far. All I can say is somehow my understanding from the facts and evidence we have, and from my medical expert, this is Dr. I forgot, McDonough. I can't remember his name. He opines based on the evidence
And
that
by
it
the
goes
way,
through the.
his credentials, there's some challenge to whether he's qualified as an expert.
Yes.
What are his qualifications? Do we have them?
30, he goes through his credentials. Let me be clear again, candid officer of the court. Our mistake, we forgot to attach his CV. In his affidavit, which we do include, he goes through his entire credentials. More to the point, the Commonwealth themselves, in a reported decision, had him as a medical expert. If he was good enough for the Commonwealth in that case, I submit a red herring. I did make a mistake.
I don't mean to distract you with this.
But he testifies that his opinion is that the bullet's trajectory, the best we can tell, is through the interior of the mouth, shattering in the temporal lobe. Interior of the mouth, left to right, not exiting the brain. That's the best information we have.
So let's assume for the moment that that's right. We'll hear from Ms. Leary in a moment.
I'm sorry, I didn't hear that.
Let's assume for the moment that you're right, that basically the gun was in his open mouth.
Yes.
And let's assume then that the better argument would have been that Mr. Don somehow obtains a gun, arguably from the car that he was, or gets some information about something about Mr. Garcia, which decides that he wants to kill him. And he basically now is threatening him, putting the gun in his mouth and saying, tell me something, admit something, which we've seen, and then shoots him then. A different argument then would have been made, but what is the practical consequence if you add up Darby and that as a different explanation of what happened? Does that amount to a hill of beans, essentially, in terms of this particular case?
Your Honor, I think I've been here enough. You know what I'm going to say. I would love to try that case. Please, let me try that case. The biggest problem, I don't want to be flip, this is a murder case. The biggest problem of all is that Mr. Garcia isn't committed to a version of events. This is, as I was saying to Justice Kofker, this is crucial to understand. The only evidence, once you get them into the general area with CSLI evidence, the only evidence that Mr. Don is anywhere in the specific area is from Shamik Garcia. His recollection is completely wrong about everything he remembers.
You're not challenging that that Garcia's testimony is accurate, that he was driving with Ms. Field.
Sure,
and that
sure.
basically they were alone in the car.
Yes, what I'm saying, sorry, if I wasn't being clear. If we accept his premise that they go off to the silver car, my point is, We know where the silver car is from the evidence. It's behind them. Garcia, the theory would be, Garcia makes a mistake. He assumes that he hears somebody coming. That's Don. Our argument will be, that person didn't get in the back. That person from the silver car, perhaps a supplier of drugs to these guys, is mad at Garcia for some reason. That person walks up to the driver's side and shoots Garcia. The main point is, he has no way to know that that person is Amos Don. What he has said is Amos Don went and got in that silver car, and that was the last he saw Amos Don, until apparently Don gets in the back seat here, which we submit it didn't happen. So the point is, the theory will be on retrial, well, it doesn't have to be. My theory on retrial, based on what I have, it will be, and I'm confident that this is a very strong theory, would be that the person from the silver car, not Don, Don's boss maybe, gets up and shoots him from the driver's side. And there's nothing inconsistent with that in the credible evidence.
So you know that there are at least 2 people in the silver car?
We don't know anything about the silver car. We know that Garcia says he's told to follow the silver car. He goes in. He's wrong about the location of the silver car, but he says Don gets in the silver car. He says that the windows are tinted. He can't see inside the silver car. That's all we know.
Okay. But it was being driven before?
I'll answer the question. The testimony from Garcia, and consistent with some CSLI and an officer's testimony, is that Garcia is seen driving the car towards the scene of the homicide. Garcia testifies, I saw a silver car. Don instructed me to follow that silver car, and I followed the car to the area. He's then wrong about saying that he does. He says he parks outside the lot. He, in fact, went into the lot, and he says the silver car is in the area. He's never right about where it's placed, but he says Don gets out of his car and goes and gets inside the silver car. He says he cannot see inside the silver car because it has tinted windows. That's all and then he says Don gets back out.
That there was a driver in the silver car who had been driving it other than Don?
I don't think that's material. I think that based on the indisputable facts we know, he could not have seen where that person came from in the car. It could have been the driver's side. There's nothing about the information we have that precludes the possibility that it was the driver of the silver car that got out and came and shot him, if that's what you're getting at.
Yes, it is.
Yeah, so there's nothing. I've given you all the information there is. There's nothing from the information that precludes any of these possibilities.
Okay.
All right,
Thank you very much.
Ms. Leary.
Good morning. May it please the court. Catherine Leary on behalf of the Commonwealth. With me today is the trial prosecutor, Ian Pollenbaum, and I would also like to recognize that the victim of the murder, Erica Field's family, is in the audience today. I'll start first with the medical records that my brother claims to be newly discovered. I want to say first that this is not a case where the Commonwealth or there was any allegation that we had extra medical records that the defense attorney at trial did not have. It seems to be kind of an inadvertent thing that happened at trial. Both parties had 620 pages. But second, it appears that the defendant is looking at this solely in a vacuum of this as relating to Garcia. It doesn't say anything about the evidence relating to Erica Field, which shows that there was stifling and soot deposition. And in the record, the medical examiner said it can happen a few feet, a couple feet away. Textbooks say 18 inches to 2 feet, not 3 feet. That would be entirely consistent with somebody having shot her.
Introduced in evidence, or do we only have the testimony about?
That's the testimony of the medical examiner of her expertise.
A few feet.
It was a few feet, generally 18 inches to 2 feet. It's more of an approximate.
Okay, and I don't mean to be hypothetical, but if someone sticks their hand through the window and shoots, how big, what car are we talking about here?
It's a small, compact car. There are pictures of it in the record appendix.
So is it possible that, I mean, again, I'm trying to understand the possibility of this other theory, but is it possible that the person sticks his arm through the window?
I don't think so, based on looking at the pictures, and also based on the nature of the fatal wound to Erica Field, which was in the back of the head right here. It looks like it was at close range. And also, if we want to look at Garcia's medical records.
So talk us through Field for a second and how Field could not be shot by anyone but in the back seat of the car. Explain that to us. And also, I don't know, by the way, we don't know if it's the same gun, right?
There's no evidence if it was the same gun which shot
We don't know
Garcia.
if there's one or two shooters even?
I think the reasonable inference from the evidence was that it was a single shooter in the backseat based on, and I will address this in a moment after I answer your question, Garcia and Field, the injuries to Field. I think that's a reasonable, fair inference. I think the evidence is strong as to that, especially regarding the soot deposition and the stifling to Erica Field, the nature of the wounds and where they were located, as well as the trajectory that Koisarek engaged in. And I would also like to note as to that, even the defense proffered expert Greg Danis says, Koisarek just says it comes from the rear of the car. He doesn't say it's in the car or outside the car, so it doesn't really, that doesn't add much to it.
Wait, hold on a second. Say that the expert, Mr. Wood's expert says what?
Greg Danis, in his affidavit, which is part of the record, says that there's a possibility that it could have come from the rear driver's side door. Somebody could have stuck basically their hand in the window and done that. Koisarek, sorry, I never pronounced his name correctly, says that...
So that Mr. Wood's expert says that someone from the outside the back of the car could have stuck their arm in and shot both people? Or is that what, that's a possibility or what?
He's saying that as to, my recollection of his affidavit is that's to Erica Field. He doesn't say it as to Garcia.
But if you can shoot Erica Field from outside the car, you obviously, I take it, could shoot Garcia from there because it's closer, right?
Well, I think the difference is, and what my brother's trying to argue, is that the person who shot Garcia would have shot him from the front driver's side window opposed to the back driver's side window.
Your theory at trial was that Mr. Don goes into the back seat and shoots Ms. Field as she turns to the left with her hand over her face, is that it? And shoots Mr. Garcia as what? As he's turning to the right?
So the theory at trial was that Mr. Don gets back into the driver's side rear seat as Garcia turns to say, "Hey, are we all set?"
Turns which way?
Turns to the right. That's the theory at trial, that the defendant either, his truth is open mouth. I think it's more likely that he, based on the damage, put the gun in his mouth, shot him. Based on hearing that shot, that Erica looked over, that's when she gets the first shot that goes through this.
So this new radiologist information is inconsistent with him turning to the right, or is it consistent from your view?
I think it's consistent, and I would also...
So explain to us remedial spatial learners how that works.
Okay, first of all, it's not new. But second of all, I think it's consistent with, if he turns to the right and a gun goes in your mouth, and the medical records show that the bullet's fragmented just up towards the right side. That's consistent with putting your head to the side and the gun going in, going up.
Can I ask at trial, it wasn't that it went in through the outside of the mouth, it was that it went inside the mouth?
It was never really discussed whether it went through the side of the face. I don't think it was suggested by the prosecutor at all that it went through the side of the face opposed to inside the mouth.
Okay.
That was not really fleshed out at trial. However, I would point out that in the original medical records that all parties had at the time of trial, in two places it says a possible self-inflicted wound. In the new medical records, it's not a conclusion that he gave himself a self-inflicted wound based on the radiology reports. It says that next to indication, which just seems that's how the patient is presenting themselves at the moment when they're coming in. These records are from the night of the shooting.
You said that it's not new, it was not new evidence.
It's not new evidence because throughout, I'm sorry, Your Honor.
Expand on that, please.
Sure, so throughout the original records, first on Record Appendix 1A, page 98 and page 62, it says it's self-inflicted. On Record Appendix 1A, page 61, 66, 89, 90 through 92, 98, 111, 116, 134, 138.
Arguing that this is a suicide. I'm confused by this.
No, but the defendant's claim on appeal is that the new radiology reports are the only things that show that that Garcia was shot through the mouth, and that wasn't contained in the original.
It's the angle that's the issue, right?
Well, that's
just help us a second, okay? So he's supposed to be turning around to the right. How does he get shot? Is it possible? And I'm not trying to be difficult. I'm just trying to understand why, because again, we got a judge who denies an evidentiary hearing here. We've got very little expert witness the first time around, which raises all kinds of ineffective assistance issues. And I'm just trying to make sure this makes sense, that we don't have the wrong shooter here.
Correct. I understand Your Honor's concern, but first, the angle and the trajectory of the
The idea that we're going to do this on newly discovered evidence when everyone goofs up and everyone thinks they have all the evidence seems to be a reach. So I'd like to make sure we've got the right guy.
I don't think it's a reach, Your Honor, especially
Billy,
because
you don't turn over the evidence. Everyone thinks they got all the evidence. Everyone's done a conscientious job of determining whether they've got all the evidence, and we're going to decide this case based on the fact that it wasn't newly discovered. Does that seem fair to you?
no, I don't think it seems unfair because the trajectory and the damage and the path that the bullet or bullet fragments took was all throughout the original records. It says gunshot wound to the right posterior skull of the base, traversing through the right cranial fossa to the right maxillary, the sphenoid sinus area, right inferior orbit, right temporal lobe. That all comes from multiple places in the original records.
Saying there's no new information that's meaningful?
Correct.
And, okay, so all of this is here before this, okay.
Absolutely, Your Honor. In multiple places. Maybe it wasn't articulated verbatim the same way, but all that, tracing the path and damage and trauma to the right side of the face and all the places that it hit is replete. I went through the original metal records with a fine comb tooth like this past week.
So when we go through
ensure that
this
this
as
was true.
carefully as you do, we're going to be able to determine that Mr. Garcia could turn to the right and get shot in the mouth, and it can come out and get lodged in his right. Because that's good, that's great, if that's the case. But I just want to make sure that we're not going to go back and say that doesn't really work, but you should win anyway.
My position is the evidence will show in the old records that's where the trauma was and the path of the trauma, which is the only thing that is claimed to be new in those new radiology reports. And second, I think that it's not unfeasible for somebody to have turned to the right, have a gun stuck in their mouth, and have that path of trauma. But even if this court is concerned, this evidence doesn't cast doubt on the justice of this conviction due to the evidence that was discussed with my brother, mentioned by yourself, about that the defendant, strong circumstantial evidence that this was the defendant who committed this.
There's no doubt that he was there. I get there's plenty of evidence that he was there and he drove to this scene of the crime in the back seat of the car because he didn't have a car. That's why the girlfriend's car is brought to the scene. I get all of that. What I'm just trying to figure out is when we've got a defendant who just keeps saying ace, 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 there's no defense counsel never gets an expert to talk about his neurological capacity. And we now have and there's all kinds of inconsistencies in his memory.
Which was highlighted for the jury at trial, and to touch upon the reliability or the claim that Garcia didn't have the capacity to answer the questions and that an expert should have been consulted or brought in to testify for the defense, I would say first, defense trial counsel, who's Steve Weymouth, did a great job bringing out all of this information through Sergeant Doherty on cross-examination and listening that I wasn't even sure he could understand any of my questions. I don't even know if he understood any of my commands. If you look at Ryan Darby's affidavit, he states basically the same thing, same conclusions that Sergeant Doherty said. Basically, it's clear from Sergeant Doherty's testimony that he couldn't follow commands, he was not really coherent, and that's what Sergeant Doherty testified to. And as to whether Dr. Darby would be able to testify that, in my opinion, he did not have the capacity to answer questions, I think that would be improper testimony because it would touch upon the ultimate issue for the jury and invade their province. I think possibly he could testify,
What's the ultimate issue? What is the ultimate issue that you think it's touching upon?
I think the ultimate issue that would be touching upon is whether Garcia had the ability or capacity to answer questions at that time.
Why is that the ultimate issue?
That's not an ultimate issue. The ultimate issue is whether he shot him or not.
I think it's touching upon that I think it does touch upon the ultimate issue about the credibility and reliability of Garcia and the jury being able to make up their decision about whether or not he's answering correctly. I think Dr. Darby could testify when you have an injury about that is of this nature. These are the possible explanations about what could happen, such as the preservation or whatever else he had stated, which I would submit do nothing to help the defendant or either cumulative.
He couldn't testify. I mean, we got an affidavit that says that with this kind of brain injury, you can talk, but you're not thinking. You're just, isn't that admissible evidence?
I think that is admissible evidence. What I'm saying is his opinion in one of the paragraphs of his affidavit saying, this person, Garcia, lacks the capacity to answer questions. I don't think that's proper. I think he could say when you have this type of brain injury or this type of trauma, you might not be coherent, you might have difficulty answering questions or following commands or whatever it is he said. I don't think you can touch upon that ultimate question about what this witness was able to do.
But I thought in criminal cases, we'll always get questions of the expert. Did he have the capacity to formulate the intent, for instance? And the ultimate issue evidence rule is always misunderstood. It's Mass Guide to Evidence 704, and it says an opinion is not objectionable just because it embraces an ultimate issue.
I would submit it would be improper. I think the other stuff would be, I understand your point and the rule, Your Honor. I think it invades the province of the jury to make that conclusion.
But it's okay for the prosecutor to say, do you have an opinion to a reasonable degree of medical certainty as to whether or not the defendant had the capacity to formulate the intent to premeditate? What's the difference?
I'm not sure I'm familiar with what medical expert would say that in what type of case. I'm sorry, I'm not sure.
Just an expert in whether or not a diminished capacity defense. The prosecutor in a diminished capacity defense is going to ask the expert about the capacity to formulate the necessary intent.
Perhaps that happens in my limited experience. I haven't seen that in the cases I've handled. I've seen them dance around the issue, kind of like I'm suggesting that Dr. Darby would be able to do. But at the end of the day, to bring it back, if Dr. Darby had been consulted or had testified, it wouldn't have added much. It was cumulative to the evidence before the jury about from Sergeant Doherty, which was highlighted in closing argument. And I don't think it can be understated the fact that the jury heard and could watch Garcia testify at trial, and there's even evidence of that in the record with the trial attorney saying, he's clearly had tremendous brain injuries and having problems answering questions. So I think in light of that, this doesn't call into question that this was not a reasonable strategy to stay away, to not consult an expert or highlight that, because I think it adds nothing.
Well, but there are two critical pieces of evidence here, right? The who did it, the ACE comment, and the trajectory of the bullets. And he doesn't bring in experts on either of those 2 points. You don't really think he gets an evidentiary hearing? I'm not saying he wins, but he doesn't get an evidentiary hearing to sort through any of this. It just seems like...
I don't think that he gets a...
And by the way, do we have any other... We had no witnesses to this besides Garcia? Is it
Correct. He's the only person who was there who was able to testify.
We got nothing else, and we don't have any they don't analyze for gunpowder in the car or anything, any of the things that you would do to sort of identify whether the shot was fired from within. There's none of that in this?
There's no GSR testing in it, but I think based on the fact of there was stifling and soot deposition on Erica Field, I think even if you go as far as saying 3 feet, that's still within the car. So that would necessarily mean that there would be GSR there, and it's speculative to think any testing would have helped the defendant's case. As far as the trajectory analysis, I don't think an evidentiary hearing is warranted.
What about stifling for Garcia? Is there any, what do we have for that? Is it just?
There's no evidence as to that. I think basically due to the nature of his injuries, and I believe it was a relatively bloody scene when he got out of the car and was walking around.
So you're telling us now that Mr. Wood is correct, that the best version of the medical evidence is that the shooter put the gun inside the mouth of Mr. Garcia. Is that what you're saying, based on the medical evidence?
I think it's a distinct possibility, and I think Garcia turning to the right and saying, "Hey, are we all set?" is entirely consistent with that.
Let me ask you. We'll have to. Let's imagine the possibility that you're wrong, and let's imagine. I'm not saying you are. That we go through the evidence and we look at it carefully and we say it does appear as if the better view of the evidence is that it appears that the shooter put the gun inside the mouth of Mr. Garcia, and it's not quite clear how the angle would have been possible based on the description of him turning to the right and the shooter being behind him. Let's assume that Mr. Wood, he's right sometimes. Sometimes it happens. Let's assume for the moment that he's right about that. What do you say is the practical consequence of that, if any?
I don't think there is a practical consequence because it doesn't take away from the evidence regarding Erica Field, as well as the other overwhelming evidence showing that the defendant was present at the time of the murder there.
Okay, so
and that he's placed in the back seat by the latent fingerprints.
So let's help me to go over the evidence that you would have. You would have the evidence with regard to the stippling and the angle, which we've already discussed with regard to Miss Field.
Correct.
You would have the evidence of Mr. Garcia that he was with the defendant up until the time of the shooting.
Correct.
You'd have CSLI that would be consistent with the view that he was at the very area.
Absolutely. The CSI showed not only the defendant traveling down from Maine to Boston earlier that day, but also with him at the exact time hitting off at 7:05, hitting off the cell tower closest to the murder scene. And that was at 7:05, and police officers started responding to the scene at around 7:10.
And what would you have immediately after, in terms of CSLI, immediately after the shooting? What would you have with regard to the defendant's CSLI?
I believe the CSI shows him back. I don't think he was using his phone in between when he was fleeing from the scene, but shows him about at 7:20, 7:30 back at his residence. So it has him going to the scene.
It's in Framingham?
No, the residence
in
is at
Springfield.
Heston Street in Dorchester.
In Dorchester, of course he's not. So is that an area that one can get to by foot from the scene of the shooting? Or is there some indication that he got a ride somehow or somehow drove there?
I'm not sure. So the last, I think it's close enough. I think it's about approximately maybe a mile or so, maybe a little bit more. So would not be unreasonable that he could have gone on foot based on cell tower last hits at 7:05. He's on the phone when he pulls into when they're at the parking lot. And then the next cell tower hit is in the late 7:20s, 7:30s. I'd also point to the evidence, and I think this can't be understated, defendant's acts of consciousness of guilt, basically saying when he's confronted by somebody from Maine, Christine Gilland, about having possibly shot the victims, saying that they would have to prove it. When she told him that she might be pregnant, she said, "You don't want to have somebody like him because he's the type of person who might end up going to jail for life and might have to kill innocent people." He told Misty Deschain that you cannot play with someone else's money or something bad will happen. The day after the murder, he lied to his sister-in-law on the reason why he wanted his phone number changed, saying that he was having problems with his the mother of his son. And then the CLSI and the mother of his son show that he went to see her the day after the murder and brought her shoes for their son that he had bought on the way down to Boston and stayed with her 2 times that week.
And I guess you'd also have the failed attempts to purchase a gun or to obtain a gun back in Lewiston.
Absolutely.
But no evidence that he actually did get a gun, except you claim, because you claim he had one when he shot him.
Correct. I think it's inferable that, and that evidence is relevant to the context of this crime. One, that the initial trying to get the gun, if I may answer this question, I know I'm over, Your Honor, that the initial time he tried to get a gun was in relation to drug dealing. He had interest in firearms with his drug dealing business. The second time he tried to get it was directly related, I think, to his heroin supply having been stolen, and he was not successful. And I think that explains why this murder had to happen in Boston, where he could make a connection and verbally get the gun from that silver car before.
All right, thank you.
Thank you.